Hello and welcome back to Coin Lady channel. Many crypto media outlets covered the story, including this headline from Cointelegraph. A few days ago, attorney Jeremy Hogan shared the main reason he thinks XRP is not a security. He explained his reasoning in great detail in a thread on Twitter. And I went into explaining his thinking. I won't bore you with a summary of everything that was said, but I will say that it was fascinating and made me think deeply about a lot of things. Judge Torres is currently considering what appears to be the central argument of Ripple's summary judgment motion, that there can be no violation of the terms of the agreement because XRP is not an investment contract and therefore there is no investment and no contract. You've certainly heard that argument before, but attorney Jeremy Hogan added some important and extremely fascinating nuance if you've been paying attention. But again, I don't want to rehash that, because I covered his very thorough explanation of why that is in great depth. Nevertheless, he has added to his opinions, which I will not do. About 15 hours ago, he published some additional ideas you had written, including the second reason why Ripple did not sell XRP as a security. This then is his most recent development. And I'd want to relay to you his precise words. As you progress through this material, you'll notice indications and revelations about who he really was. He's making a remark of sorts. To avoid being accused of putting words in someone else's mouth, I'll give you his exact words even if I'm saying they sound different from what he actually said. However, it appears that he is drawing attention to the possible general approach that Judge Torres is taking to this case. To some extent, I take this as a sign that her mind is not completely sold on the SEC. So let's dissect this whole thing and see how it works. But before I go any further, I should make it clear that I have no support of any kind, either financially or legally. I am not qualified to give you financial or legal counsel. Furthermore, you should not make any financial decisions based on what I say. I'm merely a hobbyist who likes to share his knowledge on crypto-related issues through YouTube videos. But only as a pastime and for entertainment purposes. Okay, so here's the most up-to-date piece of writing from Jeremy Hogan, an attorney. This was the second main factor in why Ripple didn't list XRP on the stock market. Foreshadowing how Judge Torres would come to the conclusion that XRP was not offered as a security is her recent ruling. Check out the how he test version she uses first. Then the important information is at the bottom of this page. I don't see the use in reading the rest of it. However, here is the screenshot that Hogan submitted with the court. The sections further down here with earnings from others' work alone are the ones to focus on. So he followed up in the next tweet with, the third criterion, as stated by the judge, is that the buyers must have been motivated exclusively by a desire to benefit from the work of others. Although subsequent decisions have relaxed that criteria and effectively removed it as the primary test, it is still an interesting one. Yes, the outlook is bright. That's something I've known about for a while. And that word has only ever appeared in the sky. Attorney John Deaton and others have brought it up. Learning more about the inner workings of the legal system, the judicial process, and so on is fascinating, especially for someone like myself who has no prior legal training. Observing the reasoning of judges over time is fascinating. The opinions of one judge are considered by another judge. The idea of a precedent became clear to me at that point. It's interesting to observe, though, how even if only one judge makes a judgment, that might result in the removal of what could otherwise be deemed crucial parts of a verdict. And going ahead, that will be the case, as the precedent has been created. So when you say solely, do you mean that the ramifications of that one word are enormous because of the work of others, or because of the efforts of a small number of entities? So, consider that with regards to XRP. Are we putting all of our faith in Ripple or the XRP community as a whole? That one word, by itself, would undoubtedly have far-reaching consequences. That, too, will be seen. That's why lawyer Hogan's bringing up the fact that she wasn't required to employ the archaic version of the test where the word solely is included. This is what she inserted. Therein is the clue. And then Hogan claims the SEC recruited an expert witness to testify as to whether or not XRP buyers were relying on Ripple's efforts, and the expert unsurprisingly testified as to whether or not that was the case. However, in her recent order, the judge blacked out that portion of his testimony. This is how that section reads. This, then, comes from Judge Torres. Beginning in early March, The judge issued a ruling on all of the parties' doorbell motions, ruling in favor of Ripple on all counts and against the SEC on none. This was a huge victory for Ripple. So, I'm delighted to inform that the following is the pertinent paragraph that attorney Jeremy Hogan shared with me back in early March. Expert witness 1 identifies 6 considerations that a rational buyer of XRP would have given weight to, and uses them to evaluate the public assertions made by Ripples. This is authored by Judge Taurus. However, he does not offer any supporting evidence for the significance of those 6 elements beyond his own experience as a digital asset investor and his keen observation of the digital asset market. Expert number 1 fails to provide any justification for why his own investment experience is relevant to the question of whether or not other people should buy XRP. He provides no references for his approach to gauging XRP buyers' opinions or actions. At his deposition, the first expert also admitted that he had not interviewed any XRP buyers for his report. Generalized appeals to an expert's past work experience are no match for solid guidelines. The quote ends there, but you get the idea. And that, right there, is a very solid conclusion. It just rips in two entirely now. You are aware of who's being referenced there. That's Patrick's job. There's your first guru. We'll call it duty. Picture yourself in a high school setting, where your last name is Judy. That certainly, positively did not go off. One must feel sorry for the guy. Right. However, he offered no supporting evidence for the claim beyond saying, in my opinion, without providing any context. He made the claim without providing any evidence or context, and to top it off, he never even interviewed a single XRP buyer. You can learn that in a deposition. That's why it's judged to be hell no, that don't make no damn sense, and discarded. Marital knowledge is unknown to everyone. Finally, Hogan believes that only the SEC's third expert witness is qualified to comment on the aforementioned criterion. In a nutshell, the third expert confirms that the price of XRP was artificially influenced by Ripple. But the test wants to know what people were thinking or knowing when they bought XRP. So, let's halt and ask, did you realize that whether or not XRP are ridiculous is not the test? Neither is whether or not Ripple tries to manipulate XRP. The question is whether or not those who bought XRP suspected or knew that Ripple had such intentions. If buyers of XRP had no idea that this was a possibility, it wouldn't make any difference even if Ripple had intended to do so. That's a far loftier standard to meet. You can see how challenging it is to do this. I love the subtle approach that attorney Hawkins takes to all of this is what truly sells it for me. Then Hogan, the lawyer, claims that the third expert makes no claim that XRP buyers were aware of price manipulation. According to the experts, Ripple's actions were covertly carried out with the hope that no one would notice. So keep that in mind. An authoritative voice adds weight to Ripple's argument. Then Hogan states that because there is no evidence linking Ripple's activities to its behavior, the SEC is left with a jumble of contradictory statements made by Ripple. Among these are advertisements, tweets, and claims that the recent rise in XRP price might be attributed to Ripple mania. When I first heard the term Ripple mania, a visual of crazy, arm-flailing inflatable tube men sprung into my head. Did you have the same reaction? However, attorney Hogan claims in the evidence that XRP buyers did not see such things. So once more, all of these claims are what the Ripple effect was aiming for. But where is the evidence that XRP holders knew of any? Nothing like this exists. And then what happened? Milligan counters that Ripple's claims with testimony from eyewitnesses. Public consensus has established that XRP is a currency, an asset, and not a security. In a class action, the SEC did find 6 XRP holders who disagreed. Ripple, however, has thousands of XRP holders who can refute such claims. Last but not least, the SEC's own expert confirmed that most XRP price swings since 2018 have no relevance to whatever Ripple performs. No reasonable juror could look at the scanned evidence presented by the SEC and conclude that the SEC met its burden of proving prong number 3 of the Howey test, because the overwhelming weight of the evidence indicates that XRP purchasers did not rely on the efforts of Ripple. Ripple is the clear winner in this case. In a second place. Who are you, great law clerk, to read this? I really hope the law clerk is paying attention to what attorney Hogan is saying for the sake of a little free assistance. It would be fantastic. Attorney Hogan is right, so that passed up the chain of command. Absolutely. There's an additional part right here. In response, a man named Seth Money wrote to Attorney Hogan and asked if judges have complete discretion in their rulings. Or does she consult with a select group of people, perhaps other judges, clerks, or staff before making a call? Most federal judges, according to Hogan's research, also have a law clerk and 1 or 2 associates to assist them. To reach this conclusion, she is seeking advice from others and employing the collective intelligence of the human race. However, the final decision definitely rests with her. But she knows what she's talking about. There are several clues that point in the direction of favoring XRP holders, even if they aren't stated directly. And I look forward to hearing the outcome of this. I have a lot of faith. Judge Torres, please don't let us down. I don't give advice on money matters. Nothing I say should convince you to treat yourself to anything. Please like and subscribe my channel. See you later, bye.